Welcome, everyone. We'll call this meeting to order at 1 o'clock. Thank you. The proceedings of this meeting will be recorded and made available on the internet. We'll ask the clerk to conduct the roll call.
Thank you. Deputy Mayor Windover, are you present?
Present?
Councillor Armstrong?
Present.
Councillor Franzen?
Present.
Councillor Lambshead?
Present.
And Mayor Clarkson has sent her regrets. For staff, we have Donna Taggart, CIO Treasurer.
Present.
Barb Waldron, Director of Building and Planning, CBO.
Present.
Adele Arbor, Planner.
Present.
Sarah Delamarter, Junior Planner.
Present.
And Bianca Dragicevic, Temporary Records Coordinator.
Present.
And Jesse Clark, Director of Corporate Services Clerk, is present.
Thank you. We'll now do the land acknowledgement and moment of reflection, please. We respectfully acknowledge that Trent Lakes, Peterborough County are located in Treaty 1. Mississauga territory and the traditional territory of Mississauga Chippewa Nation, collectively known as Williams Treaty First Nations, which includes Alderville, Bellesley, Curve Lake, Georgina Island, Hiawatha, Grandma, Scugog Island First Nations. Trent Lakes respectively acknowledges that the William Treaties First Nations are the steward and caretakers of these lands and water with fraternity, and that they continue to maintain this responsibility to ensure their health and ensure of generations to come. We will now take a moment to reflect on these principles and the duty and the responsibilities as members of council. Thank you. I'd like to remind council members of the obligation to declare any fraternity interest that they may have. I get a motion to approve the agenda. Carol, Terry, thank you. All in favor? Terry, thank you. Get a motion to suspend the regular council meeting. Carol, Terry, all in favor? Thank you. Okay. First, we'll have Adele to give preamble.
Thank you. Through you, Deputy Mayor Windover. This is a public meeting under Section 34 of the Planning Act to consider an amendment to the Municipality Zoning Bylaw B 2014-070. A notice of public meeting for today's application containing the prescribed information was circulated to all landowners within a 120-meter radius of the subject lands and at least 20 days prior to this meeting. The notice was also mailed to all prescribed agencies, public bodies, and persons in accordance with the regulations. Anyone wanting to be notified of any decision from today's public meeting must send in a written request to myself or the clerk, and the notice of passing will be mailed to them, setting out the method and manner in which appeals may be made to the Ontario Land Tribunal. Please note, if a person does not send a written comment prior to the passing of the bylaw or make an oral submission at today's public hearing, that person may not be entitled to appeal the decision. I will pass this part of the public meeting over to Barb Waldron to provide an overview of how we have arrived at today's public meeting.
Through you, Deputy Mayor Windover. Adele and I are very pleased to speak to the public meeting for Oak Orchard Development. The purpose of the public meeting today is to receive any written comments and hear verbal statements during the meeting. All of the material will be collected and reviewed by the municipal solicitor along with staff following the meeting. The bylaws will be brought to council at a future meeting for passage, tentatively set for March 8th, based on the outcome of the public meeting today. Today, we bring before you the 4 draft bylaws with the supporting report. The process to get to this point has been methodical, with many hours of staff time having gone into developing these 4 draft bylaws through meetings with Curve Lake First Nations, the Ministry of Heritage, Sport, Tourism, Cultural and Culture Industries, the Ministry of Government and Consumer Services, our municipal solicitor, and the residents of Oak Orchard, as well as many in-house planning and staff meetings. Going into the process of determining the best path forward was very challenging, given there were so many invested parties involved in the order, and in order to carve a path forward, staff had to maintain focus on 2 goals. Those were to create planning documents that would allow for development to proceed, while providing for process to address the fact that the ministry has identified that Oak Orchards in its entirety is a probable potential for unearthing artifacts based on the archaeological significance and the type and the amount of artifacts, as well as human remains being found. Oak Orchard was subject to an archaeological work 20 years ago. Further archaeological assessments undertaken according to the current standards and guidelines for consultant archaeologists has determined that the area of archaeological potential extends beyond the area assessed 20 years ago. Staff have made every attempt to be open and transparent throughout this process and have made every attempt to answer all questions coming from the public. Numerous meetings were held with Curve Lake First Nation, and when all documents were in a format to present to the property owners, an information meeting was organized for the benefit of the property owners to present the bylaws and to provide information as to how the bylaws were drafted. The realities of the current situation are as follows. Number 1, do nothing is not an option. In April of 2021, the ministry made it clear that the municipality had to do something to address the situation, which prompted the municipality to impose the interim control bylaw. Number 2, the interim control bylaw was adopted June 1st, 2021. Number 3, if appeals are received, the interim control bylaw will continue to freeze development. If no appeals are received, the ICB will be repealed. If appeals are received, the hearing dates will most likely be in and around the spring of 2023. Number 5, staff have devoted countless hours to finding a solution to be the best possible situation for all parties, given all of the encumbrances that had to be addressed and dealt with. Number 6, the building and planning department have a very heavy work plan for 2022, and the fact is that the hours spent on Oak Orchard have put many projects and work behind, which now need immediate attention. Number 7, during the process of coming to the determination of the 4 draft bylaws, staff have already reviewed the situation from every angle possible, and there were in fact very few options, and even fewer that all parties would consider. Number 8, the planning department strongly feel that we have put forward 4 draft bylaws that provide a path for development to proceed in Oak Orchards. The ministry has been a party to the entire process with the municipality, including final approval of the draft bylaws, and have indicated no concerns with the wording or drafting of the bylaw. There have been many comments regarding the municipality being the approval authority for Oak Orchard development, so I would like to clarify that all plans of subdivision, including plans of condominium, are approved by the County of Peterborough, and in this particular case, the final approval was completed at the Ontario Municipal Board level. We have received a letter of support for the draft bylaw from Curve Lake First Nation, and we have received 1 letter of objection from a solicitor representing one of the property owners located in the group of lots 10 to 19, 1 letter of objection from multiple lot owners, and a letter from a property owner in the group of lots 10 to 19. So at this time, I'm going to let Adele explain the bylaws.
Thank you, Barb. Through you, Deputy Mayor Windover. In the development of the draft bylaws that are being presented at today's public meeting, planning staff took into consideration the permissions that were allowed by the zoning bylaw that was approved by the OMB in 2006 and in effect prior to the enactment of the interim control bylaw. That Oak Orchard plan of condominium, which was established by archaeological work, was undertaken 20 years ago. That current archaeological assessments that have been prepared and completed have determined that the area of archaeological potential extends beyond the area assessed 20 years ago. That the growth plan and provincial policy both require the conservation of significant archaeological resources and does not permit development and site alteration on lands containing archaeological resources or archaeological potential. Planning staff chose to use 4 separate zoning bylaws, each of which is intended to reflect the unique development status of land use within Oak Orchard. It is intended that the proposed bylaws will protect the archaeological resources while at the same time allowing individuals that have satisfied certain criteria to proceed to obtain a building permit. This approach is to assist landowners understanding which zoning bylaw applies to their property, although there is almost no variation in the operative requirements of the bylaws as they relate to the removal of the holding provision. The 4 draft bylaws prepared include the Shoreline Residential Private Access 13A with a hold, and this represents lots 10 to 19 subject to the special archaeological constraints. There is another zoning bylaw that is Shoreline Residential Private Access 13B with a hold, and that represents lots which are vacant. The Shoreline Residential Private Access -13C with a hold represents lots which have building permits issued. And we also have another separate bylaw that identifies the open space -6 with a hold, open space -7 with a hold, and open space -8 with a hold, which represents open space common areas of Oak Orchard. Next slide will show you the actual schedules that are attached to each of these bylaws. So as I explained, lot 10 to 19. And then the next one will show the vacant lots. And then the lots where permits have been issued. And lastly, the open space lots. So that just gives you a general overview of which lots are affected by those particular zones, and they're attached to each of the zoning bylaws. It is planning staff's opinion that the most appropriate planning tool to protect archaeological resources is the holding provision. The hold essentially ensures that any development or site alteration that takes place on a property will not affect archaeological resources. The holding provision ensures that no development and no site alteration shall be undertaken on any lot subject to a hold until the holding provision is removed. 3 things must occur before the hold is removed. And in the first case, the archaeological assessment of the property has to be completed by a licensed archaeologist in compliance with the 2011 standards and guidelines for consultant archaeologists, and a report has been entered into the Ontario Public Register of Archaeological Reports with a recommendation of one of the following. No archaeological site of cultural heritage value or interest has been identified, and no further archaeological assessment is required. Or any identified archaeological site is of no further cultural heritage value or interest, or any identified archaeological site of further cultural heritage value or interest is conserved and protected in a manner as detailed in the archaeological assessment. The second provision of the hold is that the property owner has entered into a site plan development agreement with the municipality which shall formalize any recommendations of the final archaeological assessment, including recommendations intended to ensure that an archaeological site of further cultural heritage value or interest will be conserved and protected. And the third part to the hold is that a complete application to enter into a site plan agreement and to remove the holding provision shall include documentation to confirm that the licensed archaeologist engaged with Curve Lake First Nation in preparing and finalizing the archaeological assessment. Each property is being treated the same on a go-forward basis, even those properties that have been constructed upon. The built-upon lots are subject to a hold in the event any future site alteration that may take place that requires excavation and a building permit. Staff included some special exceptions in the SRPA-13A hold bylaw, which includes the minimum setback from the boundary of a private road for lots 17 and 18 was established previously at 9 meters or 29.5 feet. However, given the constraints on lots 17 and 18, the proposed minimum setback from the boundary of a private road is proposed to be reduced to 6 meters or 19.7 feet. Lots 10 to 19, which are a subject of the existing special archaeological constraints, the side yards is being proposed to be reduced from 15 meters or 49.2 feet to 2.28 meters, 7.5 feet, to allow for a wider dwelling on these lots. Staff reviewed challenged lots, specifically 17, 18, and 19, and given the 21.5 meter water yard would still apply, the side yard reduction was deemed appropriate and was applied to all lots zoned SRPA-13A hold. The definition of conserved has received the most attention and has gone through several edits by Curve Lake First Nation and the Ministry of Heritage, Sport, Tourism, and Cultural Industries, and the following definition has been agreed upon. Conserved means the identification, protection, management, and use of archaeological resources in a manner that ensures that their cultural heritage value or interest is retained, which would include removal and return to the First Nation in cases where significant resources have been confirmed through archaeological fieldwork. This shall be achieved by implementation of recommendations set out in an archaeological assessment that has been reviewed by the ministry and entered into the Ontario Public Register of Archaeological Reports. Alternative measures and development approaches may be included in these plans and assessments, including phased development or phased excavation. Archaeological assessments and request to deposit must meet the requirements of the Ontario Heritage Act. And if you'll notice that all 4 bylaws have these definitions repeated because the definitions apply to all 4 bylaws. We have received correspondence for today's public meeting from Curve Lake First Nation, Peterborough Public Health, and they are in support of the zoning bylaw amendments. We received a letter of objection from 20 landowners in regards to the expenses associated with archaeological assessments. There is a question regarding the zoning bylaw approved by the OMB and the holding provision that was applicable at that time. There is a request to lift of the interim control bylaw in addition to the approval of the 4 zoning bylaw amendments. Each of these bylaws has been drafted that the interim control bylaw will be repealed once the new bylaw comes into effect. In regards to the holding provision that was in the bylaw that was previously approved by the OMB, the holding provision applied to a site plan development agreement between the developer and the municipality, and that was registered on title. So that particular hold was removed on that property. So as you see the bylaw today, we don't have that hold because that hold was satisfied previously at the OMB. We also received an objection, as Barb mentioned earlier, from a law firm, Castles, Brock and Blackwell, regarding the inappropriate use of the zoning bylaws to impose additional obligations with regards to archaeological matters and the authority of the site plan process. So these are comments that we will still have to process and maybe get a legal opinion from our solicitor, and we will bring some report back to council on the 8th when these bylaws come forward. And that concludes the public portion, other than the next steps that's up on the screen. Today is the statutory public meeting. We are looking at council consideration of the bylaws on March 8th. And then staff will have to process a notice of passing in accordance with the Planning Act. And we hope to get that notice out on March 10th. And that will leave the appeal expiry date at March 30th. And any receipt of any appeal will proceed to the Ontario Land Tribunal. And if no appeals are received, the bylaw will be in effect and property owners may apply to start lifting the holding provision from their particular properties. And that concludes the presentation.
Well, thank you very much, Adele. Jesse, is any member of the public available to speak to the file?
Yeah, we've had Tony Timolkovsky wish to speak, so I will unmute you now, Tony.
Thank you, Deputy Mayor Windover. My name is Tony Timolkovsky, and with my wife Stephanie, we purchased a waterfront lot, Lot 10, in Oak Orchard Community in August 2020 to build a home for our family. We fully respect and appreciate the archaeological significance of our community, and from the onset, we have been proactive in educating ourselves by gathering zoning information, development site plans, surveys, and historical archaeological data from Trent Lakes when purchasing the property. By designing and placing our home to respect the archaeological constraints and zoning regulations, a septic permit was granted in February 2021. Our unique property once housed a boathouse, concrete boat ramp, parking, and other amenities as documented in the 2001 and 2002 archaeological reports. The presence of asphalt, concrete, shoreline retaining fabric, and buried piping is still evident throughout the property. In May 2021, after receiving a letter from the Ministry of Heritage, Sport, Tourism, and Culture Industries regarding the archaeological significance of our community, I spoke with Catherine Capella, Manager of Archaeological Program Unit. I provided her with a copy of our site plan for review. To date, we have not been advised of any issues with the placement of our home in relation to the archaeological constraint on our property. In June 2021, following the interim control bylaw imposed by Trent Lakes, we took a proactive step and hired Earthworks Archaeological Services, Inc. to conduct a stage 1 and 2 assessment of our property. The assessment showed no evidence of artifacts on our property, but a supervised excavation was recommended given the proximity to an archaeological constraint. The circumstances that brought us to this point are unfortunate, and with the approval of the proposed bylaw, we feel it is a step in the right direction. We look forward to working with the municipality, the Ministry of Heritage, Sport, Tourism, and Culture Industries, and Curve Lake First Nation on the best course to conserve and return any cultural artifacts found during our build. As previously noted, my wife and I extensively researched our property and are confident that through discussions with the Ministry of Heritage, Sport, Tourism, and Culture Industries, that the impact on our property is minimal. However, it is unfortunate that landowners are saddled with this predicament. Ideally, this matter should have been dealt with when the initial land development application was filed. In addition to the four bylaws, in addition to approving the four bylaws, we ask the council lift the interim control bylaw. Otherwise, we may be forced to appeal in order to ask the scope of the interim control bylaw be reduced to exclude our lot if any of the four bylaws are appealed. We look forward to working with all parties and finally beginning to enjoy our property. Thank you.
Well, thank you very much for your comment. Yes, yes, yes.
Thank you. Next, I have Tiffany Green and Andrew Watson.
Hi there, good afternoon. It's Tiffany Green here, Lot 24. We want to take the time today to say a huge thank you to Barb for taking on the role as the Chief Building Official for Trent Lakes on August 10th, 2021, and inheriting the issues Oak Orchard Plan of Development was facing. Although at times it may have felt like we, myself especially, were harping on Barb and team, we know Barb has done her very best with what she was handed. Thanks to Barb for her hard work and dedication, and for everyone else involved, Curve Lakes First Nation, the ministry, Oak Orchard residents, other planning staff, etc. With that said, back in August 2022, we didn't necessarily agree of going down the path of a bylaw amendment for Oak Orchard, since other practices such as the ministry checklist existing today to assist municipalities with planning and development. However, the interim control bylaw and zoning bylaw revisions have caused unnecessary delays and costs for those of us who followed existing practices, which include the ministry and potential archaeological site guidelines. We'd like to reiterate that these bylaw amendments have not changed our lot specifically, nor our building permit submission requirements. It's only added additional costs and time as a result of these delays. It's been 9 months since the interim control bylaw was put in place on June 1st. We have always understood, realized, and respected the importance of the Indigenous community and the protection of their culture and heritage value. With that said, we are willing to accept the vacant lot bylaws today and look forward to being able to continue to move forward after approvals and our holding provision has been lifted. Today we stand here excited to build our dream home and to provide a better life for our growing boys and family. We know it's been a difficult year. We have all shared some form of stress as a result of these delays and increased costs. We urge the public, Deputy Mayor, council members to understand these bylaws provide the clarity and path forward while balancing the need for the culture heritage protection. We ask that you accept and approve the vacant lot bylaw at minimum, so that those of us ready to build with ministry approved letters in hand can continue to develop the Oak Orchard to what we intend it to be, and to help contribute to the beautiful site many boaters enjoy as they float through the Trent Severn waterway. In terms of the open space bylaw, we do ask that we are provided the opportunity to continue the regular maintenance, which has been done many times previously. And only for new development, major soil disturbances require those archaeological assessments and hold lifted. Other than that, we accept and encourage everyone else to do the same so we can all move forward with the growing of the Oak Orchard development and community. Thank you for your time, and once again for the team and getting us to this point of providing a clear path forward.
Thank you very much for your comment. I'm sure that our hardworking staff and council members will do everything they possibly can to assist you, ma'am. Did you want to comment something in regard to this? Okay, thank you.
Andrew, I also have you unmuted. I didn't know if you had anything else to add. Hearing none, I will go to the next person that's registered to speak, which is Michael Smith.
There, Michael?
Michael, you've been unmuted, but, oh, you've unmuted yourself now, yeah?
Okay. Well, good afternoon, Deputy Mayor Windover and other members of council. I'm Michael Smith, the Michael Smith Planning Consultants. I am a professional planner and I'm here today on behalf of the owner of Lot 18, Starwood Investments Limited. I reviewed the report to council dated June 1st, 2021 regarding the imposition of the interim control bylaw and the report before council today regarding the lifting of the interim control bylaw and the 4 proposed oak orchard zoning bylaws, together with the implementation of the holding zone control and the site plan process. I also attended the online neighborhood meeting hosted by your staff in February of this year. Finally, I've reviewed the correspondence by the Curve Lake First Nations submitted to you for consideration today. First of all, I want to say clearly that my client and I fully support the lifting of the interim control bylaw. Secondly, with respect to archaeology, your staff has undertaken a very difficult task in what I believe to be a timely fashion under the critical eye of the Curve Lake First Nations, the Ministry of Heritage, Sport, Tourism and Cultural Industries, this council, and finally the owners of the private and common use units in the Oak Orchard Plan. In my dealings with your staff, I've had a few occasions to call them. They have been prompt in their responses to my inquiries and sincere and professional in all of their work. Clearly, they have worked collaboratively with the Curve Lake First Nations to ensure that cultural artifacts are being respected. Based on our review, my client and I are supportive of the direction of the bylaws with respect to archaeology. And in this regard, I think the town has achieved the right balance of protecting the rights of landowners and the interests of the Curve Lake First Nation. My client's property is subject to proposed bylaw SR-PA-13A in brackets H, which is applicable to lots 10 to 19. And my client also has an interest in the open space bylaw. My client appreciates the proposed reductions to the front yard setback and the interior side yard setback for lot 18. Again, speaking generally, my client and I are supportive of the direction in those bylaws. We do have some relatively minor suggestions for improvement, and I will be providing more detailed comments about that in writing prior to the council meeting next week. In conclusion, my client is grateful to council and staff for their efforts in bringing these bylaws forward. Thank you very much.
Thank you very much, Mike.
Okay, I'm now going to enable the raise a hand feature, and anyone else that wishes to make a public comment can do so. Okay, I have Joanne Tripp.
Hi there. My husband Michael and I own lot 42. We purchased the lot again in 2020 in August, as well as some others did, hoping to build, not last year, but this year. But we had wanted to have all of our stuff in order last year, filed for building permits and all that other stuff. And with everything that we as a collective group, council, Curve Lake, Earthworks, and all of the lot owners have gone through, I am also very grateful to the planning department of Trent Lakes for all of the hard work that they have done to get us where we are right now. We have absolutely no objection and are very, very appreciative that we want nothing more than to proceed with building our dream home this spring. We have had Earthworks and Curve Lake on our lot, where we did have a stage 1 and 2 done, which was also approved by the ministry. I have submitted that to Barbara. So we're just hoping that this all goes through on April 1st. We can all have a big party and get together, finally meet face to face, perhaps some of the neighbors that we haven't met yet. And we do want to also be able to continue to keep up with the beach, which is beautiful. My husband and I, even though it was weeded last year, it covered in weeds, we still were able to enjoy it. I think that's it. I just wanted to say thank you again to everyone, and hoping that even though we have a little bit more costs here than we had originally anticipated, have nothing more than hoping to build our dream home and finally be able to live in Oak Orchard Estate. So thank you once again.
Well, thank you very much. We'll be glad to have you. Thank you so much. Yeah.
I also have Aaron Coos.
Thank you very much. And at the risk of sounding repetitive, I'm going to sound repetitive because I think that Barb and her team deserve to hear it over and over and over again. We are the owners of Lot 1. We've also gone through a stage 1 and 2. We have a little bit more work to do, we understand, but we'll be in a position to apply for our building permit very early in the season. And that is in no small part due to the work that Barb and her team have put in undertaking a Herculean task in terms of the balancing of interests, and we think that they've done the very best that could be in the circumstances. I simply wish to urge council to pass the bylaws as quickly as possible. The planning department not to undertake any more work that may result in the delay of the passage of the bylaws, so that all of these folks who have been copied on emails back and forth for many months can finally build our collective dream homes and sit down and celebrate them together, enjoying your community. So thank you very much.
Yes, thanks for your comment. Thank you.
Okay, thank you. I've also heard that Brian Gregg may want to speak. Brian, I'll unmute you, and if you want to make comments now.
Good afternoon. Last time I think I recorded, I came across much too loudly. I hope that is not the case right now. Okay. Good afternoon. My name is Brian Gregg. My wife Jane and I own Lot 11 in Oak Orchard. I've been asked to read a letter endorsed by 20 lot owners in Oak Orchard. We, the following lot owners, 3, 4, 5, 6, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 19, 26, 30, 31, 37, and 40. Do not wish to appeal bylaws B 2022. We fully recognize Curve Lake First Nations' right and need to conserve archaeological and cultural artifacts found in Oak Orchard. We support those efforts and want to cooperate in that process. Therefore, we reiterate, we do not wish to appeal the above bylaws. We do, however, want to register our objections to the cost implications of implementing those bylaws. We are adamant that we should not have to bear the costs associated with those activities. In 2001, a stage 1 and stage 2 and more archaeological assessments were conducted on the complete Oak Orchard site before township approval of the condominium association. This development was subsequently signed off by Curve Lake First Nation and the township. Therefore, we paid for those archaeological assessments when we subsequently purchased our lands. Through no fault of ours, the extent of the archaeological sensitive areas has been increased to include all lands. This should have been foreseen by the township, knowing full well artifacts of historical significance and human remains were found on the site. Yet the township continued to issue building permits without any archaeological restrictions or warning into 2021, save those outlined in 2001. Our understanding is that if the area should subsequently change status again, we or new landowners will be required to conduct additional assessments at our cost for perpetuity. This is unacceptable and poses undefined costs and risks to us and future owners. Not only have we been instructed to pay all costs associated with any archaeological assessments, but our property values have been diminished as a result of these actions. This is patently unfair and unreasonable. We insist that the financial responsibility for this avoidable situation be leveled where it belongs, with the Township of Trent Lakes and/or the Ministry of Heritage, Sport, Tourism, and Cultural Industries. We request a response from Trent Lakes and the Ministry of Heritage stating their respective positions on their financial responsibilities. Thank you very much.
Well, thank you for your comment. I don't know how to reply to that, but we'll more likely have to get some legal advice on that. Okay, thank you.
I don't see any more hands raised, but oh, yes, I do. Carmela?
Hi, yes, thank you. Yes, and we want to thank Barbara Waldron again for all the hard work that she's put in. But, going along with what Brian just mentioned with regards to the cost of these archaeological assessments, they're not like something like insignificant. They are in the hundreds and thousands of dollars that is required to get these this land cleared. And so it's very important that what the municipality and the ministry can do for us to help us with the burden of the cost to get this job done, something that was not in the radar at all in the purchase of this property. And all the properties, it sounds like it anyway, but I just want to bring that forth. And thanks a lot for whatever it is that you can do for us, if anything.
Okay, thanks for your comment.
Brian, Greg, I see your hand up again. Were you wanting to speak again? I'll unmute you.
I'm sorry. I thought I put my hand down. I apologize.
That's okay.
It reminds me of Vinnie Barbolino, okay, in Cotter. Welcome back, Cotter. Not sure if anyone here is old enough to remember that.
That's Arnold Horseshack, I think.
Okay, I don't see any more hands raised, so I'll give one last call for anyone wishing to speak to use the raise a hand feature now.
So.
Yep, I'm not seeing any more hands, so I think we can.
Have comments from council? Maybe staff? Council? No comments? No. Sure, Terry.
Well, sure. I mean, this has been a long process and it's been
Yeah.
thousands of hours by everyone involved. And we do all appreciate the patience and all the thoroughness of our staff. And thank you to Kurt Lake and all the people who will work. It's an opportunity to move forward.
Thank you very much. I too would like to thank the council and the staff for all the hard work they've done on this. It's very, 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 very important to see staff working so hard to help our ratepayers and residents. Thank you. Well, so get a motion to get a motion to reconvene the regular council meeting. Terry and Carol. Okay, all in favor? Terry? Okay, thank you. Very good. So we get business arising at a statutory public meeting.
Thank you. Through you, Deputy Mayor Windover, there is a report on the agenda today. And this planning report, I highlighted the details of it during my presentation. So I'm not going to go through the report again. The public has had ample opportunity to review it as well. However, in summary, I'd like to say that planning staff are satisfied that the proposed zoning bylaw amendments are consistent with provincial and municipal interests as articulated by the growth plan, provincial policy statement, and Trent Lake's official plan. The proposed amendments represent good planning and are in the public interest, and therefore it's being recommended that council receive this report from the planner regarding the lifting of the interim control bylaw and proposed zoning bylaw amendments for Oak Orchard Plan of Condominium, and further that council direct staff to prepare the necessary bylaws for the lifting of the interim control bylaw, the 4 zoning bylaw amendments, and an amendment to bylaw B 2002-29 to include low-density residential housing in the designated site plan control area, all for consideration at the March 8th, 2022 council meeting, and further that council waive the payment of a site plan application fee for lands within the Oak Orchard Plan of Condominium. And I'd be happy to answer any questions that council may have on this report.
Somebody's gonna make the motion. Carol, again?
Yeah, I will, excuse me, thank you, Adele. I will make that motion, the highlights of which are that we receive this report, that we direct staff to prepare the necessary bylaws and amend the existing bylaw, as well as waiving the payment of a site plan application fee for the lands within the condominium.
Second. Peter, you second?
Yeah, sure.
Thank you. All in favor? Passed, okay. Great, second. Okay. Readoption of the confirming bylaw. Terry, yes, okay. Second, Terry, Peter, okay. All in favor? Great. Okay. Get a motion to adjourn. Peter? Carol? Scott, we're gone. Thanks.
All in favor? All in favor?
Oh. Well, okay, we're,
All in favor.
that's passed.